This is the 8th video in the Ethics and Legal Considerations for Animal Chiropractic. Previously, we've talked about the first three elements of a claim for malpractice. That is the duty, breach of duty, and proximate cause. And the last element for a claim for malpractice is damages. And this is an area where the law favors the veterinarian. Typically, in a damages case, damages may be nominal, which means there's an establishment that there was a breach of duty but no real damage, so it may be just $1. It's not something that typically becomes a lawsuit. Damages may also be compensatory. And some of the damages that have been claimed in veterinary malpractice cases include, of course, first, the fair market value of the animal. What's the replacement cost? There's also been claims for special damages, the unique value to the owner, general damages for things like pain and suffering, mental anguish, and emotional distress. Now, generally, and also consequential damages, including things like expenses, including veterinary expenses to treat an injury caused by malpractice, lost income if the animal was used to produce income, loss of use of the animal, or cost to locate a substitute for the animal. In addition to nominal and compensatory damages, when there is willful and malicious conduct, there may also be punitive damages. Now, punitive damages are extremely rare. It's very difficult to establish that conduct was willful, malicious, intentional, or fraudulent, or grossly wanton. Um, does happen, but it's relatively unusual. So the question is, when you're working on pets, dogs and cats, what's the measure of damages for a pet dog? And bottom line is the damages for the loss of a pet dog will be the fair market value of that dog, which usually is not very much. This is out of a law review article published in the Nebraska Law Review, talking about animal valuation. And essentially, the law recognizes our pets as commodities. And because they're commodities, they're just a property. The value or the damages recovered is limited to their fair market value. So it's kind of like if you broke a table or if you left a dent in the side of my car. There's no emotional anguish. There's nothing. It's just a simple, what's the fair market value of the pet? And for ordinary pets, fair market value is going to be relatively low, and rarely will it be enough to justify the expense of pursuing a malpractice claim. Now, certainly when you're working with more valuable animals like racehorses or large animals in general, you're more likely to see a malpractice claim. But when you're working with ordinary pets, dogs, cats, and the like, it's not very frequent that you're going to see a malpractice claim. Even if you do make a mistake, even if you do have a bad result, it's unlikely. Now, I'm not saying that to encourage you to make bad results or to make bad decisions, but I am letting you know that this is an area that you probably don't need to be as concerned about. You want to have that insurance in place because, like I mentioned before, the expense of fighting these claims can be much more than the amount of the claim. So here's a few examples. Burgess versus Shampooch. A 13-year-old pet dog was injured at the groomers. Now, in this case, fortunately, the dog was able to recover after the treatment. Court found that the dog is personal property, which means that its fair market value before injury and after the recovery from the injury is essentially unchanged. It's the same value, so there's no damages there. But the dog's owner was allowed to recover for the reasonable veterinarian's fees for treating that injury. Strickland versus Medlin case came out of the Texas Supreme Court. Now, I think there was some hope that when the Texas Supreme Court accepted this case, that they would change the measure of damages in Texas. They did not. Okay, this was a particularly sympathetic case. The owner had come to the shelter to pick their animal up, but didn't have enough money to pick them up then. The owner was told they could come back in a few days. The owner told the shelter that they would come back and asked them to place a hold for owner tag on the dog's cage. Due to a mistake at the shelter, they euthanized the dog the next day. That's pretty hard to explain, and that's pretty hard to defend. The owner was not told about the euthanasia until they returned to pick up the dog a few days later. And that's a wrong way to handle making a mistake. So the issue in the case was whether the intrinsic or sentimental value can be recovered for a pet dog. Clearly, this was a family dog, very close connection to the family. In the court's opinion, the Texas Supreme Court's opinion spends a fair amount of time talking about our special relationships with our pets and our closeness with our pets. But at the end of the day, the court came to the conclusion that measuring the worth of a beloved pet is emotional, but a pet's value is a legal determination. And we're focused on that legal determination. That is the fair market value, which is what the compensable damages will be in this case. So that rule has remained unchanged in Texas, despite the fact that I think this case created a fairly sympathetic argument. And I think for the Texas Supreme Court to have accepted this case, there was at least some consideration or some possibility that they may have changed the rule. They did not. Here's an example of a case out of Georgia. Mixed breed dachshund um, animal was negligently injured. When the animal dies as a result of the injuries, the proper measure of damages is the market value of the animal. May also include the expenses to cure the animal. In this particular case, the owner had spent $67,000 in veterinary and other expenses. Now, it's not often that somebody's going to spend $67,000 to treat a dachshund. But even in that situation, the Court of Appeals would be likely to reduce the damages to a reasonable expense. Here's the case out of Wisconsin. 11-year-old dog is attacked. Medical bills are $9,500 plus $2,700 for other expenses. But the replacement cost for the dog was only $2,700. The court opinion comes out like many of the others do and says very plainly dogs are personal property. And for damaged personal property that is repairable, the general rule is that recovery for property damage is the lesser of the reduction in value and the cost of repair, or the pre-injury fair market value. So it's like a total loss of a vehicle. If my car is totaled in a car wreck, I may want to spend $10,000 repairing it, but the insurance company may tell me that they're only going to pay $5,000 because that's the fair market value of my car. This is the same kind of situation, except we're talking about a dog, which has a great emotional attachment, certainly a much greater emotional attachment than I might have to the fenders on my car. But it's again, the court is making a very simple legal determination that is personal property. The recovery is limited to the fair market value of the dog, or in this case, $2,700. Here's a case out of Ohio where the fair market value of the dog was $400. Veterinary bills exceeded $10,000 to treat the injury. Again, the court's opinion comes down to what is the reasonableness of the expenses. That's not a decision that would be made by the Court of Appeals. They would send it back to the trial court to reevaluate the evidence and decide whether it was reasonable to spend $10,000 to treat a dog that was only worth $400. Petco versus Schuster. Um, and I think what you see in these cases, and in many of these cases, is a real struggle between the trial courts and the courts of appeals. The trial courts often try to figure out there's got to be some way to compensate for the loss of a pet that makes sense. And the courts of appeal tend to come back and say, nope, we're not going to go there. So here's another one where the trial court awards $39,000. Now, this was a default judgment, which means that Petco did not show up to defend against the case, but they did show up for the appeal when they realized it was a $39,000 case. Replacement value for the dog is $500. They did spend another $900 taking the dog to training school and $50 for a microchip, as well as $6,700 for attorney's fees. Yeah, the trial court added to those damages um, for lost wages, counseling costs, mental anguish and emotional distress, intrinsic value or loss of companionship, and exemplary damages. And the Court of Appeals essentially reverses all parts of that judgment except for the award for the replacement value, reimbursement for training in the microchip, and the attorney's fees. So the judgment goes from about $40,000 to less than $10,000, less than $9,000 rather. So pretty significant reduction. And I'm not sure how they were able to award the attorney's fees in this case, but somehow they figured out a way to do it. Here's a few other headlines that I've seen. Um, Central Texas woman awarded $47,000 for the Schnauzer's death. I have no indication or no belief that that opinion was upheld on appeal. Here's a Kentucky jury awarding $15,000 for the death of a German Shepherd. Jury received instructions that the dog could have an intrinsic value beyond its market value. Again, I don't think that survived appeal. Suspect that many of these cases are never appealed. They're settled for much smaller amounts instead of going on appeal. Um, Here's another one where a judge awarded $28,000 because a Rottweiler had to have its teeth capped. That's another judgment that I suspect did not stand up on appeal. California dog owner awarded $39,000. Jurors find that the dog's special value exceeds the $10 market value. They spent more than $20,000 on veterinary bills. Yeah, that looks like a large judgment. $39,000 looks like a large judgment. But pay attention to this. Bluestone spent more than $350,000 taking their case to court. That's a pretty expensive, pretty big loss on that case. So my last comment on damages, when working with a small animal, I think the damages are going to be relatively limited and relatively small. When you're working on more valuable animals, again, like a racehorse, the damages can be much more significant and your risk of a malpractice lawsuit is much higher. But I also want to make an observation that there's no connection between damages and fines. Okay, the damages may be limited, but the fines and sanctions imposed by the licensing boards are not limited to fair market value. So those fines and sanctions may be much more significant than the market value of an animal. So again, you don't want to be careless. You shouldn't want to be careless. You should hopefully want to take good care of your animals. But be aware that there is some risk. and that the risk may be more in the area of attorney's fees and fines and sanctions than in paying large judgments.